Okay. All right, guys. Welcome to our Back to Basics, the real estate contract training. Today, we're going to be going over the real estate contract. I have attorney. Why don't you introduce yourself? Tell everybody this is Kyle. He's somebody who works with us. He's out in Cranford. And why don't you tell a little bit about yourself, how long you've been in the business?
Sure. Yeah, my name is Kyle Chan. I'm the owner of Chan Law, Chan Law LLC over in Cranford. I've been doing real estate for about 7 years now. I've been an attorney since 2011. I did immigration for 3 years prior to that in New York. I do mostly residential and some commercial, depending on what it is.
Okay, awesome. Thank you, Kyle. We're going to be talking about the real estate contract. I don't know if you guys know, but essentially we as real estate agents are licensed to prepare these contracts, but it's on a pre-filled template. So that contract that you guys see on your screen and you guys see is an approved contract that's done by the Real Estate Association as well as the NJ Bar Association. So together they kind of came up with this and said, look, these are the terms that we're going to put together for a contract. You guys can fill in the blanks, right? Because anything more than that, you're practicing law and you need a license to do so. So don't go around amending this, right? This is why we have this pre-filled. And for commercial offers, we have letters of intent. We don't write those contracts. We write a letter of intent saying we intend to purchase the property with these terms, but an attorney is going to write the contract. So that's where you would hire an attorney to go and do that. So what we're going to go over, guys, is what each part of the contract says from the legalese perspective, as well as for myself. So Kyle, I don't think you know this, but and some of you guys know, but I wanted to be a lawyer at one point. So I was doing the pre-legal studies and I did my legal clerkship with the city of Elizabeth. And I took some legal writing courses at Seton Hall Law. So obviously I'm not a lawyer, but we have to give that disclosure. You cannot give legal advice. We are not attorneys. You always have to give it to an attorney to do that. However, if you can put things into context for your clients and give general ideas and always give that disclosure, like, look, I'm not an attorney. You're going to talk to an attorney about this. But if you have a good understanding and can explain some of these things to your clients, it's always helpful. You get value as an agent. All right. So that's what we're going to go over today. Anything you want to say to preface this?
You made a good decision not being a lawyer.
That's noted. So essentially, we're going to go over this. And then once we do, I'm also going to talk about the attorney review. All of you guys know that we have an attorney review period. But I want you to talk a little bit about those kind of boilerplate things that you put into attorney review letters, because a lot of us, we get those attorney review letters and we might not pay it too much mind because obviously it's not our job, but I think it's important to understand. And you guys know, a lot of our clients rely on us, so they'll call us to ask us questions. And again, you lead it by saying, I'm not a lawyer. I can't give you this, but here's my experience. And I think what this is kind of what it means, but confirm with your attorney, right? So we're going to start with the first page. So the first page of our contract is, and it's actually Form 118. And it's essentially the notice to buyer and seller. And it says to read this before signing the contract. And essentially, in my opinion, it's 7 different ways to tell you, get an attorney.
Agreed.
Right? It's like, look, this is a very important thing. Get an attorney. Get an attorney. The first thing that you do fill in is, as a broker, who you're representing. So obviously, you could be a seller's agent, a buyer's agent, or both, a disclosed dual agency, or neither. You're acting almost like a transaction broker. So you check off the right box, and then in 7 different ways, you tell them, get an attorney. Anything you want to add on that first notice?
No, just that sometimes people just gloss this over and they'll think that this is actually the first page of the actual contract.
Right.
I know it's a disclosure to say, get your own lawyer. We're not your lawyer. And that protects you as well. So you want to make sure you do get that signed, because otherwise they're going to say, well, I thought you were representing me, and blah, 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 and you just run into problems later on.
And back in the day, we didn't have this notice as part of our contract. It was actually a separate notice, and then you had the real estate contract. But what happened is some people forget to do it, and it can lead you to be in trouble. So the state has actually fused it into the one Form 118, and the first part of that form is this notice. So it is a requirement. So yep, then you have seller side, buyer side, sign it. Listing broker, selling broker. Again, guys, listing broker represents the seller, selling broker represents the buyer. And that sounds weird, but that's how it's broken down here. And then prepared by. The other provision is this: is you have to have a licensed real estate agent prepare this contract. You can't have, like, if you have an office administrator and they're just like, they're just an admin, a secretary, whatever it is, they are not licensed. They are not qualified to prepare this. Okay. So you have to keep that in mind when you have somebody preparing it for you. Okay, we move on to the next part. So this is actually the first page. One of the things that I've gotten a lot, maybe you guys have gotten too, a lot of people will tell me, like buyers, first-time buyers, will say, oh, I don't want to sign that. I want to review with my attorney first. but they don't understand that the attorney's not going to review it until it's fully executed. So how do you get over that? Well, some people don't know, but this first line, big, bold, not first, right under the NJ Realtors logo, it says, this is a legally binding contract that will become final within 3 business days. During this period, you may choose to consult an attorney who can review and cancel the contract. See the attorney review for details. So I read that to them. Guys, this is legally binding. However, you do have 3 days to go over with your attorney, and they're not going to review it unless it's fully executed. Why? Because it might not get accepted. If it doesn't get accepted, they're just spending their time reviewing something that doesn't mean anything. So that's important for you guys to know that that disclosure is right there in bold letters, all caps. Make sure you read it to them to overcome that objection. Anything on that?
No, that's good.
Right.
I've had people give the same objections, and I said, look, you want to pay me to look it over, and you're not going to get it signed. It doesn't make sense for you.
Exactly. So that's from our end. That's what we say to them. It's like, look, what can happen is they might not accept it, and then we're here. If you do get it accepted at that point, it makes sense to have it reviewed, and you have the right to have it reviewed. The next part is table of contents. You have 43 provisions and clauses. We're not going to go in detail in each one, but we are going to kind of mention them and say what they are and what parts are adjustable or amendable. Part 1 is parties and property description, obviously who the buyer is and their address. It's important that you guys fill this out. A lot of people leave the buyer's address blank. Most attorneys want complete contracts, right? I mean,
Yes.
You want that, right? Another thing to note here, and I think Kyle, you can shine some light on this. When you represent an LLC, you put the LLC as the buyer. They are the buyer, but you do not put them as the signer. The authorized representative for the LLC, it has to be the signer. If you get a contract and it's signed by 123 Main Street LLC, that is not a valid contract, right?
Agreed.
Okay, so you got to make sure that that's something that you guys are putting in there. So put the buyers, put the address, and then purchase from is the seller's information. It's pretty straightforward. Seller's information, seller's name. What I do, I tell my clients to go on the tax record, pull up the tax record, either from the MLS or from the county's website, and put in exactly what appears on the public tax record. If somebody tells you I'm the seller, don't just go off of that. Go off of the public record, because whatever's on there, that's what title is going to require for them to sign. To transfer the deed. So this, you can pick up a lot of issues. If somebody puts the seller's name on the MLS, don't just go off of that. Pull up the tax record.
Yeah.
Anything to add?
Sometimes the tax record, it's truncated. So you're only gonna get the first thing. There might be 8 different sellers who own the property, but they only have a certain amount of names that they can fit on it. So we'll find out during the title search whether, they'll look at the previous deed and see how many names are on there. But to look at the tax record is a good starting point.
For sure. The next part here is the property address. A lot of people confuse it. You could have a seller who lives in one address and is selling a different address, because they can own multiple properties. They could be absentee owners, whatever it is. So the same address is not necessarily this on both lines. The seller's address could be different than the property address. The property address is the actual property that you're looking to purchase or making the offer on. The next part is shown in the municipal tax map of. That says city in a way, but I'll give you guys scenarios where that doesn't apply. For example, when you're making an offer on a house in Colonia, Colonia is actually a part of Woodbridge municipality. So where it says shown in the municipal tax map of, you wouldn't write Colonia, you wouldn't write Avenel, you would write Woodbridge, because the municipality is Woodbridge. That's something that's a little miscommon. I've seen people write that on there. You want it to be as correct as possible. Anything?
Agreed.
Yeah, pretty much that. County, obviously the county that it's in. Block and lot. Very important to put that in, because if you mistype the address for whatever reason, the legal address would be going off of the block and lot, right? That's the property. You can mistype a address that's commonly known as, but that's not, block and lot is really what people go off of. Anything to, I know that can get a little.
Block is pretty much, if you look at this block, and then the lots are the individual units that it's divided up into. So while the street names may change, the block and lot should not. That's associated with the tax maps.
And then for the qualifier line, qualifier is typically when it's a condominium, right?
Condo, sometimes if you have a parking space associated with like a condo, you might have a qualifier, or if some property is subdivided, you might have qualifiers there. It'll show up on the tax map.
So for your average one family home, you might not see a qualifier. Just because you have a qualifier field doesn't mean that you have to fill it in, right? Next section, part 2, is just about the purchase price. I'm not going to get into the numbers because that's wasting a lawyer's time, but we'll talk about that later on with the lender and how you break down the deposits and stuff like that. Manner of payment, you want to talk a little bit about this one?
Usually you put down your initial deposit when you first sign the contract. By practice, at least from what I've seen, doesn't always happen that way, just because things can die during attorney review, so they don't want to waste time with checks going back and forth. But there's initial deposit, the additional deposit. which is the second deposit usually provided within 5 to 10 days after credit review.
You'll see that a lot of times you'll have blanks in there and it says if blank, then it's this. So you could leave that blank and automatically it'll be the pre-filled section on there. Sometimes we will fill it in when, let's say your client tells you, right, like tax season was here, right? They were getting a refund for whatever reason. They're like, oh, I'm getting my check on this date. So in that type of situation, you might say, okay, well, we're going to give the deposit on this date instead of that one. Or for example, let's just say that they sold the property or they're closing on it and they're getting the money on a certain date. That's when you could kind of mess with those dates. Another scenario could be, for example, if you're doing like pulling money from a 401k to use as deposit, you can do that, but maybe they need some time for the deposits. So I try to keep the initial deposit low, like $1,000 just to kind of show seriousness. But then the additional deposit, we typically put a different date based on their individual circumstances. It's important that you guys explain to them that it's due on that date. If they don't give that deposit, what would happen?
The seller could cancel the contract to say there's no consideration for this, or we can try to get an extension for you, but it's best if we don't have to waste goodwill early on in the process like that.
Yeah, it could become a problem. And would a buyer be in default if they don't give the deposit by a certain date that they agree to?
Theoretically, yes. I guess in practice, at that point, the seller hasn't really lost a lot of time. For the seller, they don't want to waste time, right? So they're like, especially in this market, you don't want it, we just cancel with you and just move on. But if the seller is having trouble selling the property, they really want to lock you in, they could theoretically say the term default if you're not providing the deposit by the agreed upon date.
Yeah, so it's important that you guys really try to stick to it and inform the client of that date. The escrow. So I'll let Kyle, the attorney, actually talk about escrow, but I will say this, as a brokerage, we are technically allowed to hold escrow. I, in practice, try not to. I don't want to deal with the money. I don't want to have to deal with the deposit. There's very strict rules that we have to follow as a brokerage. From receipt of the money, you have 24 hours to deposit into the non-interest-bearing escrow account, and you cannot commingle the funds. So, like, let's say somebody gives you $1,000 in cash, and you put it in your pocket, and you have other funds there. You're technically commingling. You don't want to deal with that stuff. So, I always tell my clients, give it to the attorney, and I let them handle that. You want to talk a little bit about escrow?
Yeah, that's true. All attorneys, most attorneys, not all, because some practices they don't, but most attorneys will have a non-interest-bearing escrow account. That money is put into an account that's specially set up for client funds. And so we put it in there. All the interest goes actually to the state to provide funding for indigent people who need attorney assistance. Usually we put it either in the buyer side, will hold it. Sometimes the seller's attorney says, well, no, we're the ones who are selling property. We want it so that we know that it's there for good faith purposes. Practically, it doesn't really matter. The money remains the buyer's, and unless both sides are in agreement, the money can't come out anyway. So either for closing, or if there's some sort of breach, the seller side can say, hey, you've breached the contract. We're going to hold on to this deposit until we figure out what the damages are, or until there's some sort of negotiation as to how to release that.
Yeah, so sometimes we'll put it in on the contract as like the buyer's attorney is going to hold it, and a lot of times in the attorney review letters, the seller's attorney will put in that they're holding the money. What I tell my client is, look, it doesn't matter. At the end of the day, correct. I mean, what would happen if a seller's attorney gives that escrow money to their client without authorization?
He would get a bargain plate.
Yeah. So no attorney is going to risk their license doing that. The attorney is going to be. Yeah. So you guys should explain that to your client, like. They are not authorized. Just because the seller's attorney is holding it, they can't just give it to the seller. Even if the seller wants it, the attorney is going to explain that to them. So, they shouldn't have too much fear about that.
And I explain it to the buyer side as well. They're like, oh, you're my lawyer. If I want to get it back, you just hand me a check, right? No, I can't do that either. Yeah. So it's just protected for both parties' interests and both parties' sides. Yeah.
Gotcha. Section about the buyer's performance, and performance here would mean
purchasing the property, completing transaction.
Yeah, so it's a legal term. Like, if you perform on a contract, means that you're doing what you said that you were going to do, right? So here you're saying you're going to buy it. Their performance is subject to obtaining a mortgage. This is one section that would get waived if your client is doing like cash. They could choose to waive it, or they could not. Here's the thing about negotiating these terms. Just because you have a cash offer doesn't necessarily mean that you have to waive your mortgage contingency. Some people don't know that. You can say, I'm going to buy it in cash, but if you keep the contingency in the contract, the buyer can try to get a mortgage in the meantime. If they fail to do so, they can still buy cash. So whether or not they get the mortgage, some people are confused about that. You make a cash offer and you waive this, but if they choose to go with a mortgage and they get it, they can still close that, right? Yep. So This part, I think, is something that only comes into play with mostly investors. You don't deal with this too much with like regular home buyers. Any notes on this, Kyle, that you want to talk about?
So, yeah, this is typically what we call a mortgage contingency. And during attorney review, this is a section where most attorneys will just replace the whole section because they want the language that they're comfortable with, that they've crafted. So in my attorney review letter, I usually say, depending on representing the buyer or the seller, if on the seller side, I want them to say, I'll tell them, look, you can have your mortgage contingency, but I want you to apply for your appraisal in a very timely fashion. From the seller's point of view, remember, time is money. They don't want to waste time. So the faster you can do your appraisal or get the buyer to do their appraisal, the faster you'll know if this mortgage is going to get approved. If it's not, then you just cut ties and move on to the next one. From the buyer side, we typically want to extend as much time as possible. So we want to delay applying for the appraisal until after home inspection if possible, because you don't want to waste money paying for an appraisal if you're not going to be satisfied with the home inspection anyway. So this is an area where during a review, we will craft it in ways that'll benefit our respective clients, and it'll be different buyers and seller sides.
Yeah, and if I'm not mistaken, the mortgage contingency here doesn't actually have appraisal language.
It does not.
So that's something that a lot of times immediately the buyer's attorney adds that in, because if you read this clause, it does not mention the house has to appraise. That's something that the attorneys typically put in. Do you know why that is? Or
it's put in there kind of implicitly, but it's not explicitly addressed as an appraisal. So if you look at line 74 to 75, 76, so it says buyer shall obtain a mortgage commitment from the institution under the following terms, and there's a certain amount that for the principal and the amount of money that they're applying for. So if it underappraises, say you're buying a property worth $400,000, usually lenders will lend on between 80% to 95, 97.5% of that. If the property appraises for $300,000, well, they're only going to give you money based upon that $300,000 appraisal. That $100,000 difference is the difference between the two. And since you're not getting the full amount of mortgage you're looking for, you theoretically can terminate under the mortgage contingency, but it's better to have that appraisal language in there as well.
Yeah, more explicitly. And then this is also the part where like when you go to like quote unquote waive the appraisal, right? So a lot of this happened in the last 2 years where a lot of people were waiving appraisals. There's not really a language about it per se. So we had to kind of add it on the additional provisions, but then really let the attorneys put it into legal terms where you say, okay, look, this mortgage contingency is explicitly not including an appraisal issue. If the house is not appraised, my client will cover the full amount or will cover a gap up to a certain amount. That's where you really let the attorneys kind of put it in. So a lot of people ask the question about how do I waive an appraisal? There's no specific language. You would kind of mention it in the provisions and let the attorneys write it in the proper way. Anything else on this, huh?
No.
Good. Balance of purchase price is just really saying that, you've gotten your initial deposit, you've put in your second deposit, you've talked about the mortgage and the amount that you're getting. So what's the difference there? Well, typically what we do is, let's say it's a 20% down payment. I usually tell my client to put 5% between the initial deposit and the additional. So there's 15% that they still have to bring to the table. That's where this number comes in, and also the time. So it's talking about the actual date of the closing. I've seen different attorneys put in different things. Like I'll have attorneys that sometimes will tell me, oh, well, I usually put 45 days for closing or 60 days for closing, which I guess is very prudent from their part because they want to give the buyer more time. But in reality, the question should be had with the lender, because every lender might have different backlogs, or they might have quicker programs, or maybe they've already run that file through underwriting, so they can probably close faster. So that's more of a conversation that you have with the lender, and then you have to communicate that with the attorney, because otherwise the attorney is always going to try to protect the buyer and give them more time, and then the seller's attorney is going to always try to give it less time. So that's one of the points that there's a lot of negotiation and wiggle room with. Anything you want to?
No, I mean, in the standard, we'll talk about this a little bit later on. Time of the essence is a concept where if the deadlines are hard, they're set in stone. Usually as attorneys, we do both sides, buyer side and seller side, we'll just get rid of that and just say, hey, this closing date is the targeted date. And it's important, at least for me as an attorney, to explain it to my client, because they might be trying to time their end of their lease, the move out date, along with their purchase. And then something happens, you got to push it a week. And they come to me and they say, Kyle, being kicked out of my apartment, where am I going to live for the next week? And I said, I told you, don't rely upon this date. It's a target date. So, it's something to keep in mind for all these closing dates.
And you guys call it no automatic waivers, right? That's kind of like a provision.
There's no automatic waivers, and there's no automatic time of the essence for any date in the contract.
Gotcha. So those are like terms that you guys might have seen in the review letters, and that's pretty much what it means. It's like, just because, and we'll talk about it too in the home inspection, just because you might not have here in the contract, it kind of reads like if you don't have your report by a certain date, then you're waiving that. You're done with it, right? every
automatic waiver.
right, every single attorney removes it. I've never seen an attorney that doesn't remove it. So some people might just look at the contract and say, oh crap, you know, the seller side might say, oh, well, you didn't give me a report by the 7th day, which you agreed to on the contract. So therefore you're not making any requests. And then the attorney's gonna be like, no, did you read my letter? You know, it's paragraph 3 said no automatic waiver. So that's one of those things that we can talk about. Same thing with time of the essence. The date is a target, but it's not really binding because of the attorney review letters, not because of the contract, which is why the attorney review comes into play. I've had situations where either buyer or seller don't use an attorney. When there's no attorney and they don't do an attorney review letter, then it does become a hard date, right?
It does. I mean, if buyers and sellers both agree, yeah, everything's legal until someone tells you it's not legal. So if both the buyers and the sellers, they say, you know, the date's supposed to be Monday the 1st, and they both say, hey, we're both not ready. Nobody's going to bring it to court. Nobody's going to care. But if you end up in a situation where the buyer's ready, the seller's not ready, that could be a breach on the seller side if that is still a hard date.
Right. And a lot of times, if there is no attorney letter, then it may be considered.
Yeah, default, yeah, whatever it is there.
Sufficient assets, just pretty much the buyer is certifying that they have enough money that they're promising to bring. And us agents, we ask for proof of funds when something is cash, or we ask for a pre-approval letter. And the pre-approval letter, the lender will be the one verifying that those funds, those assets are actually there. I think that's pretty much it to that one.
Sometimes they'll say, we'll add in attorney review that you don't need to rent out or sell other property or to purchase this one. And if you do, then you definitely want to, for you guys especially, if your buyer needs to sell something or rent something, you should definitely let at least me as the attorney know this is happening so I can protect them in that manner, because otherwise there's no provision to protect them in this contract.
Yeah, so it's not a specific provision. There is additional addendum that we have. And if you guys go on Transaction Desk, all the New Jersey realtor forms are there. And there's a specific addendum saying this is subject to that, right? Yep. So you check the little box, you let the attorney know, and you send that addendum to sign it. It's always better. I've seen a lot of people not include these addendums. It's always better because the language is there. It's there to protect it. You can't just say, like a lot of people put in, like for sales concessions, they'll put on the additional provisions. Sellers provide $10,000, but there's like so much more that goes into that, right? That $10,000 has to be part of the purchase price. The $10,000 they're paying, sometimes they're paying commission on it. Like there's a lot of things that have to be discussed. So that's why the addenda is important. And then sometimes even the attorneys will modify the addenda based on whatever they want to put in sometimes. Yeah. Accurate disclosure of selling price, just saying that you're not giving money on the side, the price is the price, and the IRS is going to look at the HUD and that's what they go off of. And you can't say, yeah, I'm going to give you 500,000, but then I'm also going to throw you 10K on the side. Like that's illegal. You should all know that, right?
I've had sellers come to me before. They say, can I do this? And I said, no, that's not legal. Can I still do it anyway? I can't be your lawyer. I don't think you should do it. Well, can I pay you? No,
you're making it worse. At that point, you got to give them a shovel and say, keep digging your grave. So yeah, it's very important. You guys should read it, obviously. Items included in sales. So from a, and again, this is like you guys have seen the lawyer perspective, the realtor perspective. My job, right, is to try to fashion it in a way that's negotiation terms, right? What's more advantageous for us, and then obviously the attorney's job is to protect them legally from what they can and cannot do. You guys know that a fixture comes with the house, right? And we know the definitions of fixtures. But let's say you're showing a property and they saw a pool table in the basement. That's not a fixture. But then let's say you get to the closing and the pool table's gone. Now your client's mad at you because you showed them and you maybe didn't specifically include it. If your client says, I really love that pool table, oh my God, I can't wait to da-da-da, bless you, I would put that into the items included in sale, right? If it's in that provision right here in this box, you are saying, and the seller signs that and accepts it, you are saying that that comes with it. That is included in the sale. If you do not put it, it does not have to be there. And I've had situations where buyers expect certain things just because they thought it was included and it wasn't at the closing, and they want a credit and all this stuff. Have you had situations?
Yeah, I think the strangest one I had was they had custom shelving built into the walls. And there was a debate as to whether that was included or not included, whether it was screwed in, whether it was a fixture. And one side felt like, oh no, it's custom shelving. It's included, it's attached to everything. It's like everything else that's attached to the walls. And the other side felt like, oh no, this has sentimental value for whatever reason. They took it all out. And so we ended up having to deal with that at the end, at the closing table, because buyers going through the walkthrough and say, why do they have these things here? Like I wanted the shelves. And so I think we ended up getting the seller to bring it back over the next couple of days afterwards.
So you probably held an escrow until it came back.
Yeah, we held a small escrow because the seller, because there was just such a fundamental misunderstanding, and the seller had thrown it out, and it was just removed. So
yeah, so that's an important thing to know about the inclusions and exclusions. My rule of thumb with brokers, I tell you guys all the time, if your client really likes something, make sure you put that into the inclusions. Worst case scenario, the seller's going to say, no, I'm not including that, and they'll cross it out in the initial, whatever, but at least it's been understood. You don't want to deal with this at the closing table when tensions are high, people have their stuff packed in their truck, like that. You want to deal with this now. The other way to go about it too, and look, not every agent is good, so they don't always put it. But on the MLS, when you list a property, you're supposed to put the inclusions and exclusions. There are fields for it. So what I do is I pull up the MLS sheet and I'll find whatever it says there and I'll copy and paste it. Or I'll write in as per MLS number, 3814, whatever it is. And then what you do when you reference the MLS sheet, you want to print that MLS sheet and incorporate it into the contract. A lot of people don't do this. It's very, very important, because what happens is if you don't do that and somebody goes on there and later they change the MLS sheet, right? I mean, look, there's ways that we can find out what was changed and we can see what date it was, but just to protect yourself, you want to include the MLS sheet the day that you make the offer, because that's how it was displayed, right? That's what was being advertised.
Agreed. Also, us as attorneys, we don't have access to MLS unless like the public version of the MLS. So sometimes I'll need to go look it up if it's not included. So if you include it in the contract or when you send it to offer, I love it. It's great. It makes my life a lot easier.
Yeah, and so look, it even says it right on the contract. If reference is made to the MLS sheet and or any other document, then the document reference should be attached. It's all explained right there. The problem is a lot of agents don't read it. It's okay. This is why we're having this, right? We're breaking it down back to the basics. This is how we should do business. Yes.
What numbers?
Number 6 and 7 items included in sale and items excluded from sale. So when I take a listing, I usually walk with my client and I ask them, are you leaving the appliances? Or if I see something, are you taking that? What's included in the sale? What's extra? Is the pool staying? Above ground pools is a big thing. Sometimes they're included in the sale, sometimes they're not. Be specific. You don't want to have misunderstandings and arguments. Yes.
To include and exclude the items that also be us, the attorney can go with.
So yeah, it could be done. Attorney can modify any and every portion of this contract, right? So if you miss something, that's okay. Yeah, you could always bring it up later on. Look, you can advertise something as one thing on the MLS, and then it could be a completely different thing on the contract, because the MLS is just you advertising. But let's say that they make an offer and they say, hey, look, we'll give you your price, but we want you to include the pool, which you had as an exclusion. Then you just put it in the inclusions, and this overrides it. So this overrides the listing agreement, and then the attorney review letters will override the contract. So any further revisions, but once they're done with attorney review, that's it. The only way to override it is a mutual understanding and mutual agreement by both parties in writing.
Correct. And also sometimes it's the other way around. I've actually had some clients say, hey, get rid of this above ground pool. I said, are you really sure about that? Is it, yeah, I don't have any kids. I'm not going to use it. I don't want to be falling in. I don't want to maintain it, whatever. So, big items that you assume people want or don't want, it's better to check and make sure rather than to just assume one thing and then find out the other way later on.
So this is a portion that a lot of people don't utilize when negotiating offers. Here's one thing that I would give you guys. What I do, if the seller has a lot of stuff, or if it's like an estate sale or like certain situations, one of the items that you can negotiate to make your client's offer better is say, look, include all personal items, leave behind whatever you want. Because technically in here, it says that they're delivering the property to you in a broom clean condition. So they're supposed to empty it out of personal belongings. But that costs money. They have to pay somebody to come do it, or it's a big hassle. They have to pay a dumpster, whatever the case might be. So if you want your client's willing to deal with that, include that as one of your terms. It's not always about throwing more money at the situation. Sometimes the terms will make a big difference. Okay. Anything else we want to hit on that? I think this is one of the, so besides price and besides the terms of the financing, whether you're doing a mortgage, whether you're waiving appraisal, whatever, this is the first item on the contract that I think is very negotiable and you can help your client have an edge up. By the way, when I make an offer, I don't just write it all in there, because what happens is some agents are so bad, they don't even look at these specific items. They'll look at the price, they'll scroll down and they'll look at the closing date, and then they'll close it out and tell them today, you got a 350 offer for, closing on October 5th. That's not all of it. So what I do is when I send the email, I give them a little, review, and anything of note, I tell them in my email. And then if there's anything that I think that they should present, I'm making their jobs easier because a lot of them are lazy. So I'll say, look, tell your client that we're doing this. It's referenced in here, but just summarize it. Dates and times of performance. We've talked a little bit about this, but Kyle, please.
Yeah, this is the part about time being of the essence for performance. So usually we just delete this whole section and we'll just reword it or keep some of the language that we do like. That's a very short version of it. We don't get rid of this. The dates and times are of the essence, meaning that they are hard deadlines.
Yeah, so a lot of times when you're asking your client to sign it, they might be afraid. They might see this and say, well, what does it mean? All the dates are included as, essence. Well, explain that a little bit. Again, you're not a lawyer, but this is why you're hearing the lawyer explain it. So you can kind of use those words verbatim, but then say at the end of the day, your attorney can modify this. Whatever you don't agree with, you're going to go over it with your attorney and then they can make any change whatsoever. So we'll add some leeway. This section actually has a new part that was added in recently.
138.
Yeah, 138.
Yeah.
So the
longer than usual.
Yeah. So this section right here, if you guys see 138 through 141. So you'll see the numbers on the left side. Those are the lines that we're referencing. It says buyer selects blank as the closing agent as the title company, attorney, or other entities to conduct the closing. Before, you used to send it to the attorney and then you guys would figure out who's handling the closing. Now you can actually write this in there. But just like anything else in the contract, this could be amended. You can leave it blank and not have one and let the attorney figure it out. A lot of times they will do that. If you have a title company that you work with, obviously what I like to do is talk to my attorney first and say, hey, are you familiar with this title company? Because the title company and the attorney are going to be dealing together way more than you and the title company. So if I have a title company that I want to work with, I just want to make sure my attorney is good with them and they have an open line of communication so that we don't run into issues. But you could put in here the title company right from the beginning. But remember, the attorney review letter can modify anything. So anything else on this, or we're pretty good, right?
Pretty much it, yeah.
Okay. Number 9, certificate of occupancy and zoning compliance. I have something long-winded to say if you want to hit it first. Go ahead.
All right. So, the first line there says seller makes the representations, and in the review letter, I always have a seller make representations. When I'm representing the seller side, I always say we make no representations. Do your own due diligence, right?
Yeah.
But on this buyer side, we want the seller to make every representation possible so that if something comes wrong, we have options. As a buyer side, we like options. We like being able to change things on the fly if we need to. So if they make a representation that this is good for a single family house or a 2-family house, and they realize later that it's only zoned for 1, we want them to be able to say, hey, this is not what we were intending to buy. We can cancel it out. This essentially just says that the seller.
Question, does that also apply when the buyer is responsible for the certificate of occupancy?
Yes, it could.
Yeah, well, in what way?
Well, in the sense of, let's say, the zoning, so would that be, something that if it's not zoned for a 2-family, they'll be able to cancel the contract because it's not, and that's what they thought it was, or?
Well, if the buyer is taking on the responsibility of getting the zoning, it's definitely something we should talk about before we get to the closing, get to the closing table. But if the buyer is saying, hey, I'm going to buy this and I'm going to get this as a 2-family house, if I'm the buyer's attorney, I would say, hey, go check that out. Hopefully before we get out of attorney review, or at least get some sort of assurance that this is going to be doable. If we can't, then I'll put in there, hey, this is going to be contingent upon the property being available for a 2-family. And then, it's better to disclose, right? Because then that becomes a conversation between the buyer side and the seller side. And if the seller side says, you know what, no, I'm selling this as a single family. If you want to try to zone it for 2-family, that has nothing to do with me. You want to take that risk, you can do that. And so it's better to talk about that beforehand before it becomes an issue. And then if the 2 parties can't meet, then we just, you can either move on or you can try to figure out a way to save the deal. And say, hey, if it doesn't work, we'll lower the price, or however you guys want to handle it, just to keep the deal moving forward.
I'll tell you something in that specific regard that I've done. And a seller's agent got really mad at me because I did it in a sneaky way to protect my client. Essentially, I told them, I was like, look, we're going to be responsible for CO application and inspection. I didn't make my client responsible for the actual CO, right? So anything that comes up from it, I still threw it onto the seller side. But the way I put it in, I had the conversation with the attorney wrote it in just like that. The buyer is responsible for paying and applying for the certificate of occupancy and attending the inspection.
Yep.
That's all we're doing. We're not waiving the seller's responsibility on the CO. We're just paying and applying. And then there was a CO issue. Yep. And then they try to make the buyer responsible. Say, no, man, my only responsibility was paying, applying, and attending the inspection.
Yep.
There's an issue, you have to fix it, right? So there's ways to get creative on it. The seller's agent didn't catch it. The attorney didn't think much of it. And we got away with it. And we still made them responsible. So again, a lot of this relationship is crafting things that are in the best interest of your client and making sure that you're protected with the language that he's going to be able to defend what you agree to. So that's where the jargon comes in. On the whole use, right? With zoning, you can make the buyer responsible for it, but not waive the ability to get it. So what I mean by that, because section 9 talks about CO and zoning, but section 11, the quality of the title, if you look at lines 185 and 186, it says, well, go one line up, 184. It says the seller represents to the best of the seller's knowledge that there are no restrictions in any conveyance or plans of record that will prohibit and or use and or occupancy of the property as a blank family residential dwelling. So even if you are trying to make yourself responsible for the CO, some municipalities, believe it or not, do not check the zoning to give a CO. Okay, so a lot of people will assume that. I've had clients that have bought properties off market, they get a CO thinking it's a 2-family, and then they never did a zoning review. I had a municipality recently that happened. So the guy bought it, they gave him a CO, and it said, you know, he applied for it as a 2-family, and then when they went to do permits, it turned out that it wasn't. Why? Because sometimes the departments are different. Sometimes the CO department might be handled by like health. Like in Rahway, the health department used to handle CO. Now they put it under property maintenance, which is actually a division of engineering. It depends on how they do it. Some municipalities have it under building, and then zoning is on the building too, for the most part. It really depends how they do it. So it's town by town. So there is an argument to be made, even if the buyer is responsible for getting the CO, the use that the seller is selling it as can remain as whatever you want it to be. You could be explicit about it. Okay. So again, this is what I was saying, like I was going to get long-winded on it because this was my specialty, right? I do land use, and then I used to work for the city on this stuff. So CO is different from land use. South Plainfield, they don't even have an inspection. You just certify that all these fire alarms and the smoke detectors and everything is where it has to be. Nobody comes out to the property. That's their CO. So this is a very broad, nobody actually comes out. Like during COVID, Kenilworth, they just wanted me to take a picture of it and send it to them. They didn't check. Yeah. The pictures. Yeah. So it's important for you guys to understand that, you know, this is not as protective in every municipality. Like some municipalities have robust ways, like Elizabeth and Linden do a fire inspection, and they also do a CO inspection, and they'll check for different things. But as far as like use and like, you know, zoning for it, and we'll talk about this. I mean, we can go here for a long time, but like Oprah's, like having an Oprah request to see the property card and stuff like that. There's due diligence that you can do to find out, but don't assume that this protects you in all regards.
That's one of my favorite languages that blocks in the contract. As a investor, you can use it to your advantage or disadvantage. So, like sometimes, you know, as an investor, I feel like I'm responsible for COs, or even if the seller is, you know, we put like sometimes like I don't know if it's there. You guys should talk about the dollar cap.
Yeah.
Because sometimes, like, you know, you kill the deal because the amount to fix the CO issues, you know, you could argue like, look, this is the cap and that's it.
Yeah.
As a buyer, the deal I want, you know, calls my attorney, I tell them, look, like, I'll be responsible up to X amount, so the deal doesn't get killed because of CO stuff.
Right. Yeah. So
you know, you know, there's a lot of negotiations in that area.
yeah. So when we try to amend this, caps are important. What degree of responsibility is the buyer accepting on the CO? What are you doing for it? Those are all important factors. By default, the contract says that if you leave it blank, if the cost to repair to be able to get a full CO exceeds 1.5% of the purchase price, then that contingency, you can choose to cancel the contract. So let's say there's a big issue and it's going to cost $15,000 and that's higher than the 1.5, you can actually cancel the contract because of this. When buyers are responsible for COs, you could put a cap. I've done that before, and I tell them, look, guys, just handle it. In my experience working in this town, I think we're not going to have an issue. But however, put that you're responsible to $1,000, and if it exceeds $1,000, then it's not your responsibility. That is a negotiation point for sure. Yep. Anything else you want to say on this?
Yeah, no, $1,000 is a good cap. If it exceeds that, it's probably going to be way over that in order to close it out. So it's a good escape contingency for whoever's responsible for the CO.
Yeah, for sure. Municipal assessments. Let's talk about that.
Yeah, municipal assessments are, I guess the way that I explain it generally is if you have a year with particularly a lot of snow where you need to fix the pipeline on your particular street, the municipality needs to spend more money on your particular area. They may charge you more money in taxes for that particular year. And so having the seller present that they don't have any assessments against their property during this time. If something comes up, then usually we deal with it based upon how it's been written out in the contract.
Now, question for you guys. Do you normally check a box here or you leave it blank? On section, clause 10, at line 156. So you say that, anybody else?
I check as not.
Okay, yeah, municipal assessment, leave it blank. So, right, so that's why I bring it up, because we don't talk about this enough. I always check has not been notified. Because I'm representing the buyer, so even though I don't know if the seller has been notified, I want them to attest to that they have not been notified, right? If you leave it blank and they don't fill it out, that was never made. So by default, I have my pre-filled contract, it's usually checked off as has not. And then if they have been notified, they have to now tell us in there, oh, we're amending this section because we have been notified and here it is. But if they say nothing about it, they're not really making a representation. So even though you represent the buyer when you prepare the contract, you should check off has not been notified of municipal assessments, because when they sign, they're agreeing to that. And if they did that and they were notified, you can get them on, right?
I will thank you. Then I put it in my letter anyway. I say seller makes this representation. I have, I think, down to G, I think, A to M. All these representations from the seller side, and that's included in one of them. But if it's already there and they cross it off and they put yes, they have been notified, then at least I know in the beginning to be aware of this and to look out for it.
Yeah, so that's one item that I know a lot of people don't do. So that's why, again, back to basics. Let's put that in right from the beginning. Quality and insurability of title. I mean, look, this is a long-winded thing to say that the title is free and clear of liens and debts, right? I mean, anything specific that you want to talk about?
It usually is where you get a title company to come and make sure the title is clean, marketable, and insurable at regular rates. You might have something that's insurable, but you got to pay like 3 times the regular amount for it because there's some title issue with the property. So it's got to be clean, marketable, and insurable at regular rates. They might use different language here, but those are the 3 tenets that you usually want to hit.
Right, and then here is the section where it talks about the zoning and what kind of family dwelling, like 1 family, 2 family, 3 family, 4 family, whatever it is. This is where you would put in that number. And this is a representation that you're buying it only if that's what comes back on the title.
Yeah, and if for 186, again, I would thank you if you guys do put single family, multifamily, whatever, at least so then I know to be aware of that, because I don't go to the property. And so if I look at this property address and I think it's a single family, but you've actually told the client, hey, it's a 4-family unit, you know, there are certain things that I need to do for beyond 2-family units,
Right,
for the DCA green card, bulk sales. We'll talk about that later on. There's a bulk sales notification. So it helps me a lot if I know that it's a single family or 2-family, or it's a 3 or 4, however many unit that thing is.
Yeah. The more information, the better. When you're representing the buyer, the more information, the better. If you're representing the seller, the less information, the better. I think that's kind of what you're getting out of this.
Yeah, pretty much. Buyers want to know everything and sellers just want to get rid of it.
Yeah, pretty much. Possession and occupancy. So this is another part that's negotiable. So some people, I guess newer agents might not understand that you could close on a property with tenancies, right? I mean, not only multifamilies, but also single families. Then this is where you get into like use and occupancy agreements and stuff like that. If you put in here that, possession and occupancy are 2 separate legal terms. Do you want to break that down a little bit? I mean, it's pretty standard, but
possession means like you have the right to the property. Occupancy means you have the ability to move into that property. So for example, if you're buying a property, single family, let's say I'm renting out to George here. He's got a lease that ends at the end of the year, but I buy it today. I have the right to the property, but his lease gives him the ability to stay in the property. So he still has the right to occupy. I can't just say, hey, I own this now. You got to get out of here. There's certain provisions or certain times when you might be able to terminate a lease early, but that's kind of beyond what we're talking about. Just know that sometimes you can, but generally you need to respect the lease.
And the whole of it is that some people don't understand that you can close and still not get occupancy. Right? So this is the section where you can go into that. And when you're buying multifamily properties, or when you're buying a house from somebody who's living in it and then has to buy something else, this is one of those times where you can negotiate maybe the terms will trump like pricing. So if you put that the tenancies are applicable, that means you're accepting these tenants. And here, make sure when you're writing the offer to ask the listing agent for the information. If you don't know if there's a security deposit, if you don't know how much the rent is, all these different things should be ironed out now. You could technically do it during attorney review, but maybe it's something that's bad and you don't want to deal with it. So you want to know all the information up front. If you put the tenancies are not applicable, that means that when you get to the closing, the property has to be vacant. That's what you're agreeing to. But if you are accepting with tenants, you have to make sure it is applicable, and you want to state how much the security deposit. I've had situations with security deposits that nobody asks, and then last minute they're just trying to scramble, and sometimes my client has been stuck without getting it because they didn't do it. They didn't do it in the beginning. So that's pretty much possession and occupancy. Anything to add on that?
Yeah, if you're gonna fill this out, and you got to check not applicable unless you know there is a tenant. See if you can get a copy of the lease or to confirm, just the names, fill out all that information. It makes it really, really helpful on the attorney side. And also for your own clients, they might say, hey, this lease is gonna end a month after the closing. That's something I can live with. If it's gonna end a year after the closing, that might be something they can't live with. And the lease is also gonna have these really good terms, like how much they're getting paid, the security deposit amount, all these, the terms of the lease are really important for, if I were buying something I want to know in making an offer.
Yeah, like how much notice is there, like a rent? I mean, like that's a whole different line that we can get into on leases for sure, but it is important to have that information. I will say that a lot of people don't know kind of what goes into some of these things, so I'm going to hit it briefly. So tenant's name, whatever names appear on the lease, you want to include here. It's not just who's living there, it's the names of who people are responsible on the lease. Location, meaning like if the property is a two-family, you have a first floor, second floor, or like if it's a left unit, right unit, whatever it is, that's what it means by location. Make sure you specify that. They're not asking for like address, location within the property. The rent is the monthly rent amount, not necessarily what's on the lease, what they're actually paying. Sometimes some landlords that are like smaller mom and pops, they don't do a new lease. They just raise the rent and they don't have something in writing, right? So like the lease that you get could say a certain price, and then they can tell you that they're paying $500 more a month, but they never did something in writing to do it. If you put it on here on the rents, that's really what counts. And then you get a copy of the lease. And if you see that the rent amount here that the listing agent told you does not match the lease, at that point, it might trigger for you to ask for them to have something in writing with the tenant before you inherit that. You want the landlord to do a document, this is to certify that the rent is X amount, whatever. Like these are a lot of things that you can do your due diligence in the beginning. Security deposit. Again, the seller transfers the security deposit to the buyer at the closing table through the HUD. It's not like the deposit is being returned to the tenant and then the tenant's going to give it to you. So if the lease says a certain amount of security deposit and they're telling you it's a different amount of security deposit, make sure you figure that out before you close. And then at the closing, you transfer it out, and then they give what's called an attornment letter to the tenants to say, look, I am selling the property and I'm transferring your deposit at the amount of X to the, like everything has to match. And it all starts here. You want to fill this in here, that way you don't have discrepancies. I've seen so many potential issues get squashed when we actually fill this stuff out. And then term is like, when is the lease over? Like it's a 1-year lease, expires on this date, whatever it is. So write that all in. Anything else there that we?
No, it's all good.
Okay, this is the latest change to the contract is lines number 213 and 214. This just came out last month, 2 months ago, the whole lead-based paint thing. Do you want to talk about that a little bit?
Just on a very high level, it's certain properties that are being used for rental purposes, they're required to be inspected for lead paint issues. You either get a certificate or you get some sort of exemption for it, or if the property is built after 1978. Like the CO, each municipality does it a different way. And since it actually came to law last year, it became effective in July. So they're still trying to figure it out. They had a year to do it and they still haven't figured it out yet. So not all municipalities are up to date on this, but it is primarily directed at properties for rental.
And in Union County, I'll tell you that Elizabeth and Plainfield are the only 2 cities that have required dust wipe inspections. So like if you have it, they actually require them to do a sample and send it in to make sure that there's no lead there. Other municipalities in Union County have opted to do visual inspections. And there's different ways that they can do certifications of a visual inspection. So just understand that this is one of the changes. It's on there. It has to deal with properties built before 1978. Definitely check in with that municipality as to what their requirements are.
What do you guys see this like moving forward if we deal with like I was talking to Carlos, right,
Yeah.
about this? Like is it gonna be like a CO where you're gonna get a certificate to like resell? Or?
Yeah, so it's it depends on the municipality. Some of them are building it into their CO. So like for example, Linden, if you do a CO in Linden, part of the CO, you have to give them a termite certificate. You have to give them the fire certificate, and they did something else. Well, now like they can add this as another certificate. So like when you go to do a CO, you have the inspection, but on top of that, they might say, okay, we need your LBP, the lead-based paint certificate, whatever it is.
That's right,
Yeah.
that's third party.
Yeah, so third parties do it. Pretty much every home inspector you deal with is probably going to. Yeah, I want to open a home inspection company. Now, so yeah, it's a thing that you'll have, you'll have home inspectors now start advertising, hey, I'm licensed to do lead-based paint inspections. In reality, they collect the sample just like radon. They collect the sample, they send it to a lab, and then they get a report, and that's your certificate. That's how it's really going to be handled. How serious the municipality wants to be about it, different story, Like Linden, they ask for a wood destroying insight. Like no other municipality that I know of does that.
Yeah, yes, that's rare.
Yeah.
They encompass it into their regular CO process. That's ideal because then everything's all there.
Exactly. Yeah. So that's pretty much that. On that same token, lead-based paint, for prior houses that were built before 1978, we are required to give this pamphlet, right? EPA pamphlet entitled "Protect Your Family." How many people have actually given this pamphlet out? Yeah. So you are technically supposed to do it. We have a digital version of it that you can provide. Back in the day, I used to give the actual pamphlet, but you are technically, like, that's what the law says, that we have to give this pamphlet. Now, the buyer is acknowledging that they received it, right? So if they sign your acknowledgement, then you kind of cover your bases, but theoretically, you're supposed to give this pamphlet, right?
Just email it over. Super easy.
Yeah. But how many people do it? I'll tell you.
I downloaded it just to read it. I was like, oh, that's what's in it.
Yeah, that's cool. Not many people know what it is. So that's kind of what that is. And essentially there's there's 3 sections, 4.
The D is the new one.
Yeah.
The rental.
Inspections, yeah. So there's 4 sections to this, and it talks about, so like you check off if it's applicable or not applicable. It's applicable if the house was built before 1978. And if so, these are the things that are agreed to, right? So definitely read it. Definitely, if you don't have the pamphlet, we'll give it to you so you can provide it. It has a warning just saying, like, look, it was very common to have lead-based paint in a home until we found out that it was a hazard. Now, because of this, we have these processes built in. It talks about inspections. This has been there for a long time. Essentially says that you are able to inspect for it. The reality is most people don't have a specific lead-based paint inspection. The new law does require it to be a little more serious for the municipalities. So that's what section D. It also talks about rentals. And I don't want to get too much into this, but even if you're not selling the property, there are inspections that have to happen with lead-based paint now. So
you kind of want to do it anyway. You don't want lead paint in your system. It's not a taste test type of thing where you want to just test yourself. Yeah, I got it.
Any questions on this? Anything you want to add?
No, it's just, you don't want to live with lead. So just figure it out and then notify your sellers. This is something that they probably don't want to be living with either. So let them know.
Number 14, point of entry system is not common here in Union County. I don't really know where it would be.
I think it's probably out in where
Like
wells.
west?
Yeah, probably out where there are
Northwest.
wells where you're getting water not from a public source. They got to treat the water coming in to make sure there's not enough. Septic is for weight. Poet is for water coming in.
Yeah, I do have a deal right now where we had a situation, there was a well, we had the testing and the municipality. Yeah, the municipality just passed this new thing where to sell part of their CO is that you have to submit a well test, right? And then some of the municipalities, the septic has to match like the amount of bedrooms, like the bedrooms are limited by, so there's a lot of like very specific like provisions. It doesn't apply in our neighborhoods, but if you do have a point of entry system, you want to ask the listing agent. You're making the offer, you're the buyer, ask the listing agent, hey, you guys have a poet? Like, is that a system that you have? And if so, then it's applicable. If not, then it's not applicable. And then it provides protections for like inspections.
Check this box if you can. I have never dealt with this and for the properties I deal with, but I know that it happens. It's in this provision. Sometimes if there's an oil spill or something, and there's water contamination and you're getting water from the ground, that's kind of where the systems come in.
So the house that I'm purchasing right now, well, I'm representing the buyer. They have a well, we had the inspection, and it turns out that the levels were beyond what's accepted by the municipality now. So the seller had is like $6,000 to do a filtration system and put that in. So this is a very important thing in some places. So be familiar with it. If you don't know, ask. Okay. And worst case scenario, if you have to leave it open for confirmation, you could always call like the municipality and say, hey, what's the water system in this area? And then you can figure out if it's public or not. Cesspool is a very similar thing, but on the other end of it, almost literally. So if the cesspool is applicable, then all these sections are on there. again, it's more about protections and inspections, so we don't have to get into it too much. The one section that we really get into with inspections is item 16, right? You want to talk about it? I mean, this we can spend a lot of time on.
We
But
can spend a lot of time on, I don't know how much time you guys wanna.
Yeah,
get
no.
into it, but the buyer generally, I tell them, look, you get your inspections, all the inspections you want to do. I tell them to, hey, if you want to do an Oprah, it's a good idea. If you have an agent, I think you guys generally just do the Oprah anyway for your clients. So sometimes they don't, sometimes they forget. So I just tell them, hey, do the Oprah. So at least that way we know if there are any open permits. I'm not going to know if the seller put in a new HVAC system without a permit because I don't go to the property. But if you go and you say, hey, you know, this sticker looks like it's from 2001 or 2021, and you pull the Oprah and there's no permit for it, okay, that's a red flag. Say, hey, that's probably unpermitted. Attorney should probably look into this because I'm just looking at pictures. It looks fine to me. And then through the inspection too, sometimes the home inspector will be able to tell you about those things. Just on a macro level inspections, I usually tell them, get an inspector, go in. You're not buying a brand new house. I set that expectation with the buyers. Unless you're buying new construction, you're going to have some issues with it. Typically, you want to bring up as issues any major issues with the appliances, the water, the systems, the roof, the structure, environmental elements like radon or oil tanks. Oil tanks, there's another section on that. Let's talk about that for a while. Usually you just bring that to the seller. And so I say, if you don't do your inspection now, particularly with sewer pipe inspections, if you don't bring it up now, speak now, forever hold your peace. And you can't come to me later on and say, oh, during the move out, I realized there's a big hole in the wall. Well, was that hole in the wall there when you first got it? Yeah, but I didn't think it was that big of a problem. Well, then you can't really bring that up now. If there's new damage when you're doing the final walk through, sellers break a window on the way out, that's something we can bring up. But inspections, do it. If you're going to waive it, I make sure that the buyer knows exactly what that means and how much of a potential issue it could be if you choose not to do any inspections at all.
So it's broken down into different like sub clauses. So like section 8, it just talks about like, you know, there are different things that you can do. Like there's different inspections. Like we said, the most common ones when we do home inspections is the like structure of it. They check the electrical, the plumbing, the roof, things like that. And then there's additional inspections like the radon test, the wood destroying insect test, the oil tank sweep, the chimneys inspection, level 1, level 2, sewer scopes. I mean, there's a million things you can test for. So what I tell my client is, look, if you're gonna do it, this is the section that talks about how much time you have to do those inspections and then how the process works. And essentially you inspect, you get a report. If there's an issue, you request it, and then they have a chance to come back to you. Either I'm gonna fix it, I'm not gonna fix it, I'll give you credit, negotiate, cancel, whatever it is that happens. It's all broken down here. The important thing to know is when negotiating 2 things. I typically don't waive home inspection. You might say waive home inspection, but some agents don't understand what that means. When you say I waive home inspection, I would tell you to limit home inspections to structural items or environmental things. So we still have the right to have a home inspection. They have to provide the access because here, legally, now they are signing to allow you to come into the home and do an inspection. If you waive it completely, you might not be, you know? So here I tell my clients, look, we're gonna have a home inspection, but we might not make any requests of you. We're gonna take it as is. So we have the home inspection. If something major comes out, we'll tell you. And if you wanna fix it, great. If not, we can walk away. But if you completely waive it, that means that no matter what comes up, if you inspect the property and there's a big issue, that's it. That is not a way for you to get out. So it's a very important thing to notice between waiving and limiting, right? Go ahead.
Yeah. So sometimes but we're buying this house as is, and it's really important to make sure that both sides are on the same page with what that means. Because from the seller's point of view, as is mean for them, they typically take that to mean, oh, you're not asking for anything. Whatever you see is what you're getting. You're not asking me any questions. What you see is what you get. And I, as buyer side, I say, look, you're buying as is. It's the sellers. We're acknowledging the seller's not planning to fix anything, but we still retain full rights to inspection and termination. I want to make that real clear because sometimes you end up with using the same terminology, but 2 different understandings, and you end up with issues. Same thing with the terms for informational purposes only. You know, if you put that in there, it drives me nuts because sometimes, you know, if I'm representing the seller, I could take the approach and say, well, for information only, that means you have no right to termination because it's only for information, right? Whereas the buyer side, they might mean that, hey, I'm only doing this for my knowledge, but I still want the right to terminate. I'm not going to ask you any questions. So be real careful about using how you use the terms as is and for informational purposes only.
Can we put like buyer limits home inspection subject to mechanical
Yeah, yeah, you can do that.
Yeah,
You can do that.
and normally when you put that, the attorney's still gonna put their own jargon on it, right? Because we normally do it on a one-liner and then they'll put it in like a paragraph, right? And it's to protect the client. I think that's getting to the point of what I was saying. You're not waiving the contingency. It's still a contingency. You should still always have it as a contingency. So what you shouldn't say to your client, oh, we're buying this with no contingencies. Because don't do that because you're essentially saying you're buying it yes or yes, right? So it's very, you can get into a slippery slope with that. My advice to you, talk to the attorney about it and just, just say, look, this is what we want to do. How do I word it? Or I put this in that section. I just want to make sure we're all on the same page, and then he'll put it in his attorney review letter specifically.
I'll call the client at that point and say, hey, this is what we're planning to do. The seller. So usually the seller will put, hey, we're selling this as is, or if the buyer saying we're going to buy it as is. Usually the buyer wouldn't, or you're going to say we're still going to do our inspection, but we're going to limit our termination for these purposes.
I think the only way it's as is if you actually have no contingencies, right? If you're waiving the contingency overall, that's as is. As is, but with the contingency of the inspection means, look, either we accept it or we cancel it, but you still have the right to cancel it. I think that's the biggest factor here to protect our clients. Radon, it talks a little bit about that and kind of talks about dates and stuff. All of this really gets built into one like home inspection contingency period, which typically is 14 days. The attorneys will normally have a boilerplate, even if you limit it here. What I tell my clients when we're trying to negotiate, I would call my home inspector. I work with the same home inspector for every single deal. And I call them and say, hey, I have a buyer, we're going to be under contract by like Wednesday. Can you come out on Saturday or Sunday? And if I know that they can be out there Saturday and I've already kind of pre-scheduled it with, no commitment kind of thing, I can tell my client or the buyer, we're going to conduct home inspection within the first 7 days, right? That might be a really big factor because if you're looking at 2 deals and they're not waiving or they're not sweetening the pot, but I'm saying, look, I'm going to tell you by this weekend, if inspection is good or not, they know that there's no harm in going with us because they might lose in the worst case scenario Thursday, Friday, and then they can theoretically back on market on Monday, right? So that's something that I have that's very strong with my relationship with the home inspector. I call them up and I said, look, I want to do it on Saturday. And when I make the offer, I tell them I'll do the inspections within 7 days. Now, I'm not making everything due within those 7 days. Like I'm not saying that the home inspection contingency will be settled within 7 days because sometimes it takes a couple of days to get the reports. Then the attorneys have to review with the client and we have to send a letter and then there's a lot of back and forth. But what I do tell them is in here, I say, I guarantee I will do the inspection within 7 days. Why? Because I've already checked with my, home inspector for that. Radon, WBIs, wood boring insects or WDIs, wood destroying insects is like termites, carpenter ants, things like that. That is also kind of rolled in of our inspections, but there is a separate section for it. The buyer's right to inspection is telling you that, this is a part, it says buyer acknowledges the property is being sold as is condition and the contract is entered to based on the knowledge of the buyer, value of the land and whatever is on the property. Essentially saying like, look, we are taking it as it is, but there is still a contingency. It's already written on there. Anything you want to add to that?
The reason for that is the sellers want to say, look, if you're putting an offer for 400,000, you say, oh, well, I did this inspection and then realized that your garage is falling apart and I need to tear it down. So I want to offer you 350 for it instead. The seller's gonna say, well, we went into this contract, the understanding that, this is the condition of the property, what you see is what you get. If there's new damage that you didn't anticipate that you really completely didn't understand, then you can use that as a basis to say, oh, well, we all thought this thing was gonna be fine, but actually the structure of the building is bad and that's actually gonna fall apart. You can use that as a basis to ask for credit. But as is really means that, what you see is what you're gonna get and that's your offer is based on what you're seeing.
Mm-hmm. So that's the right to inspections. Responsibility to cure essentially says like, look, you as a buyer can find problems, but the seller has a chance to fix it. Now they have to fix it correctly. And that's where the attorneys will qualify that by saying like, look, this is going to be fixed by a licensed contractor or whatever the case might be. So in this part, you have to explain to your client, like, yeah, there might be issues, but they do have a chance to fix it. You can't, the buyer technically, and correct me if I'm wrong, cannot just say, oh, we had our inspection, we didn't like it, we're out. Right? Like they have to give the right.
They cannot usually. So usually in my letters, both buyer side and seller sides, if something costs more than either 5 to 10% of the purchase price to fix, then either side has the right to terminate. And that's for major circumstances, like if there's a giant flood that comes through and wipes out everything. Buyer might have concerns about mold, the seller might not want to fix it, or if a tree falls on the property or falls on the house and just knocks out a floor. If it's something major like that, yes, we try to put in provisions to allow both parties to cancel. But generally speaking, if the seller fixes it, then and fixes it correctly, the buyer can't cancel for those reasons.
Yeah, so sometimes you guys might have clients that try to do that. You gotta
I
understand
had
that.
clients do that.
Yeah.
Or try to do that.
Yeah.
You can't do that.
Yeah, so that's something that some people don't understand. With that too, and I think there's another section on qualification of inspector. It can't be the buyer's dad saying, "Oh, this is a structural defect." It has to be a licensed inspector, right? Like we've all
That's
had
their
that.
license, yeah.
Yeah, it has to be a licensed inspector saying that these are real issues. Like the buyer can't say, "Oh, that floor looks wonky. I'm canceling because of it." That's not a qualified inspector. There has to be a licensed inspector in New Jersey. That's another section here. I've had that.
Next time, I
Yeah.
had this one guy give like 5 pages. It looked like it was black and white photos, which you can't tell anything on a black and white photo. And it just looked like, just typed all in lowercase too. This is wrong.
This is wrong.
I'll bring that inspection report next time. It was just
Oh,
awful. We actually got an extension because yeah, this guy got scammed. Our buyer got scammed by some inspector. Could we please have an extension? Just look at this report. And the attorney said, yes.
The flood hazard area, some people don't know, but you do have a built-in contingency that, the seller should know if their property is in a flood zone, but sometimes, flood zones change and they might not know. So they might list the property and represent that it's not in a flood zone. You do have technically a contingency here says that after 10 days, once you're done with attorney review, you have 10 calendar days to find out if it's in a flood zone or not. If it is in a flood zone and you didn't know that, you do have the opportunity to cancel the contract. Now, that being said, I know a lot of sellers' attorneys that remove that language or they modify it in some way.
They usually limit it to within 10 days. I mean, for me, while I'm doing attorney review, I'll just jump on the FEMA website and I'll just put in the address and see if it's listed as a flood zone property. It may not be up to date, but at least it kind of gives us an indication as to whether the property is likely or not likely to be in a flood zone. And I'll tell the buyers, say, hey, this might be in a flood zone, this might not. Take a look, be aware, and see if that's an issue for you.
Yeah. So for us, we have Remind built into our MLSs, and Remind has a flood map right on it. So it's super easy. You pull up the listing, hit the Remind, and it gives you the map right down there. I usually just save it as a screenshot or a print out PDF, and I let my client know. A lot of the clients, ask that, so I just send that to them.
Oh yeah. If you send that to the attorney, I'll love you for it. It just makes my life easier that way.
Yeah, so that's pretty much that. We just had a whole training on flood insurance. So if you guys want to get more information on the NFIP and like rates and stuff like that, check out the training. We have that. Qualifications of inspector. This is the part that says the buyer's dad does not count as a qualified. No, it doesn't say that, but it says a qualified inspector would be somebody licensed by the state of New Jersey or certified by. So that's important. I typically have the home inspector that I use for everything. I trust him. He's licensed. Normally, clients will say, "Oh, I'm going to look online," or like, "I don't want to spend too much." Like I tell people, there's a couple of things in life that you don't want to be cheap on. Your attorney or your inspector are definitely two of those. Like you got to make sure you get the right coverage for it. Megan's Law. Talk about that.
I've never had this come up. Never had anybody modify this, but
I had it come up.
Oh, did you?
Yeah,
oh, tell me.
Yeah.
It's pretty much if there's a sex offender, there's a sex offender registry. So if you end up on that list, it's not great. So you have the right to look online and see where you're living and see if somebody's on that list, and you can factor that in as a buyer insurer if you want to live in that area.
And it's a contingency, right?
Well, the 17 says that you as professional real estate people don't actually have the right to find out this information, but you as a private individual can find out, can access the sex offender registry. And
so what is it like? The property or the
it's more of a disclosure in the contract. Normally, there's not really a contingency for it. I've actually, honestly, I've done many closings. I've never had anybody. I had a situation
come up. So essentially, if you go on, you look up the Megan's Law registry, you can go on there, type in an address, and there's a radius. It'll show you if within, I think, 500 feet. If within 500 feet, there's a registered sex offender. It's not a contingency, like you can't get out of the deal, but the point is that you give the disclosure while the contract is not binding.
Yes.
So that if somebody was going to search it and then they go and tell you the day before the closing, shit, I just found out that the neighbor is a sex offender and I have 2 little kids, I'm killing the deal. Well, you gave them a notice to say you have the right to check that.
Yeah.
Right? So again, this is a conversation that should be had, and I know no agent has this conversation. I didn't have it until it came up one time, and there was a sex offender. So look, I don't want to get into it too much, but like you could end up on the sex offender list if you like do public urination, right? Like that's another way to end up on it, because yeah, your indecently exposure is so like, there's all these different things, but whatever the case might be, you're doing your job and saying like, hey, check the registry before you go under contract. That's pretty much what it says. 17 and 18, it shows you how to do it. And again, you yourself cannot, right? It says neither seller nor real estate broker or salesperson make any representation of the accuracy of the registry, but you want them to at least search it up, and the website's right there. Yep. Okay, notice regarding offsite conditions.
Every town has a list of, if you're living near an airport, is probably the big one, or if you're living over a previous industrial zone where there's like contamination or something. Every town has a list of possible offsite conditions that would affect the value of this property, and this is just a disclosure that says, hey, buyers, you can go take a look, ask the clerk of the municipality anything that's affecting this particular property. If you don't ask, you don't know. It's not really a contingency to terminate the contract, but it is more of a disclosure, similar to the Megan's Law Registry.
That's pretty much what it says there. 20 is the air safety and zoning notice. I mean, it talks about the airports, and there's a whole extensive list of which municipality and what airports they are. If you live close to an airport, you're like, there's the air rights, like people can complain. I don't really want to get into like, oh, I own up to the sky, like, but you can get into situations where people like, maybe they move in and they complain about like the planes and stuff like that. Well, you're showing them right on the contract. Here's a list of every airport that we have registered and the name of the airport. If you're not on one of those municipalities or close to it, then you're good. It's part of the
It's
contract.
part of the contract.
It's already there.
This is paragraph 20, I think it was. 20. Yep. Starting with line 435.
Yeah, and it's not like every single one. It's like about air safety, right? So if you read it, any person who sells or property in the air safety zone set forth in New Jersey zoning act, whatever, it says that, like for example, Newark's not on here, right? I don't think it is.
Newark might be a little bit lower on.
No, it's not.
No,
Yeah, because it's not. It's. I think these are like smaller.
So they want to prevent like building, like putting like lights that might distract the planes, or something deal with it. They have regulations and restrictions on your property because there are airports there. So this is a disclosure that, hey, there's an airport here. There might be limitations on how you can use your property. I actually had a client a long time ago. He was buying a property out in the west, and like a week before closing, he said, oh, by the way, I don't want to buy this unless I can build a helicopter pad on this property.
Jesus.
What? Wow. We have never had this conversation before. And he said, yeah, I told the agent, worked with this guy for about 2 months. It's that type of property. Did you know about this? No, he never said anything. And I said, I told him, look, you don't have a contingency to cancel. Like, you'd have to go through the zoning for it, see if you can get it. You might be able to, but you can't terminate the contract for this reason anymore. And he said, well, all right, you know what, I'll just buy it anyway, and I'll figure it out later on. Wow. He's got the money for it, so I didn't feel too bad.
Oh, yeah.
It might be a restriction. You want to build helicopter pad, you live close to an airport, you might not be able to.
Yeah, right.
First company deal. Talk to this guy here.
Bulk sales. This is a big one definitely for some type of properties.
So bulk sales at a very high level. If you are just buying and selling things between two individuals, it's not like a business sale. It's fine. It doesn't affect you. If I were to go to ShopRite and I were to buy a truck, they're not in the business of selling trucks. They're not in the business of selling real estate. They're in the business of selling groceries. If you are buying assets that a business uses in their outside of their ordinary course of business, you need to notify the Division of Taxation, and they will send you a letter that says, we're not going to keep an escrow, or keep $50,000 from the seller's funds because we want to make sure that they're fully paid off on their taxes, their tax returns. So it does not apply to single or two-family homes owned by individuals. So this comes up because sometimes you might see properties that are owned by an LLC. An LLC is not an individual. So for every single transaction with an LLC, I have to file a bulk sale notification. It's just a one-page document that I file to the state, and the state will come back and send me an escrow letter. It's not that important for the buyer unless you don't file. it's important for the seller because if the buyer doesn't file it, the seller doesn't care because the buyer pays the penalty. So the very short version of it is buyer should file it. Low risk, there's no cost to file it. Very high risk if you don't file it, and it's something that the attorney should pick up on.
I've had deals that get delayed because they don't get filed or the state might be backed up and then you don't get the bulk notice and then you have to wait until the state reviews it.
Yeah.
Can you also talk
10
about,
days. Yeah.
can you also talk about the like ordinary course of business? Like I've had situations where
Oh, there.
attorneys will,
Yeah, so if you go to what are big like Habonian, Kehoe or Lennar, I think is one. There's like a bunch of developers where their ordinary course of business is to buy plots of land, build a house on it, and sell it. That's they consider their inventory. Whereas if you go to like ShopRite, their inventory is groceries, right? So for somebody like these developers, you don't need to file bulk sales because that is their ordinary course of business. But if let's say I were to start off and buy a plot of land and build a house on it and I sell it, I don't have enough business history for me to make that assertion and say this is my ordinary course of business. So in that situation, you would need to file for the bulk sale notice. To make sense? Questions for that?
Yeah, it gets complicated for sure, especially when you're doing flips, right? And a lot of people do one LLC for that one house.
Yeah, that doesn't apply.
And, yeah,
You need to file it.
Yeah, you still have to file it. These are the types of things that you got to make sure, because if it's not done and then there's an assessment tax on it and your buyer buys it without the bulk sale, they're accepting that penalty.
Yeah, 99% of the time your attorney will pick up on this.
And it's
So
built into the contract,
it's
right?
right in there. So
yeah.
you just need to know that it's in case the buyers ask about it.
Yep. Notice to buyer concerning insurance just pretty much says like you're gonna have to put homeowner insurance on the property to cover it.
Just disclosures. Most of the paragraphs from this point on are just going to be disclosures to the buyer.
Yep. Maintenance and condition of the property just says that the property is going to be maintained, and then when they deliver, the seller delivers it, it's going to be in a broom clean condition. That's like always a thing that comes up. Like some buyers want a professional cleaning to be done on a house when somebody moves out. They're not entitled to that. Broom clean condition means that there's no big crap on the floor, right? Like that's really all it is like it's swept condition. So if somebody brings up an issue at the walkthrough, like, oh, they didn't fully clean this, look at the windows, like that's not what was promised to you. It's broom clean.
Yeah. There is a hidden condition here on 510. The seller states that to the best of seller's knowledge, there are currently no leaks or seepage in the roof, wall, or basement. So it's kind of hidden in there, but if you leave it in there, then the seller is representing that the roof doesn't leak. And if it does leak, the seller has then therefore made like a false representation. So the buyer could say, hey, the roof leaked, you didn't tell me, I want to terminate this contract for this reason. There's kind of like a sneaky way to get out of it under this provision.
Risk of loss just says like, God forbid there's a fire or damage, and except for wear and tear, that's the seller's, right?
Yeah, I mean, it's
on the seller's issue.
It's not sellers. Usually if there's some sort of, this is where we put the 5 to 10%. If there's a major fire and it costs X amount of dollars to fix it, this is where we typically put in that buyer seller can terminate the contract.
Initial and final walkthroughs just in the contract allows you the right to come into the property, because like this is a question that comes up a lot. Like, does the buyer legally have the right to come back into the property whenever they want? Right? Like you don't have that. You have a right to an initial walkthrough. You have a right to a final walkthrough. You have the right to the inspection. All these rights are stated in the contract. You can't like argue that in the middle of the transaction. Like I want to go back today. I want to go back next week. Like the seller does not have to give you that right. So that's important for you too. You can ask for it, right? And if the house is vacant, I'm sure they'll work with you. If it's not a big deal, they'll go with you. But some buyers want to go back like regular basis and
Go back and take measurements. Yeah.
I have one right now. We can schedule that for Saturday. Adjustments at closing. We want to talk a little bit. I mean, this is like title stuff. But...
Oh yeah. So I just want to draw your attention to line 523, the latter half of it. If any, and one half of the title company charges for disbursements and attendance allowed by the Commissioner of Insurance. So in South Jersey, I forget what the delineation is, but South Jersey, they don't typically use attorneys. Sometimes they will. Oftentimes they don't. They just have agents negotiate certain portions of the contract, and the American Bar Association, they sued, and that's where they drew the line. At some point, agents are quasi allowed to practice law in a sense by representing their clients in a certain way. And north of that, you cannot. In those, most of these southern counties, they pick their own title company. And because there's no attorneys on either side, the buyers and the sellers will split the cost of the disbursements and attendance. So it's usually like $500 to like $1,000 split in half, depending on which title company you use. So we usually just take that out here in North Jersey because the title company is picked by the buyer. It has nothing to do with the seller, as their attorney, buyer's attorney. So we take that out. The adjustments are typically, what you see here, preparation of the deed is normal. Their attorney prepares it. Realty transfer fee is like you can say it's kind of like a sales tax in a way. Lien discharge fees is like a mortgage payoffs normally. You continue down, prorations are usually for property taxes, water, sewer. If there's leases, if there's an oil tank, you're splitting the cost of the oil, whatever you get adjusted for those amounts. And I think that's more or less it. There's some stuff about FERC bill later on. Yeah.
We don't really have to cover that.
Just keep in mind that if you know the seller is a foreign individual, just let your attorney know. And it does not, it just means that there's a tax or some withholding that's required. There's nothing else about it. It's just something to be aware of. Let your attorney know. They should be able to figure out what to do with it.
And your client can have like dual citizenship if they are a US citizen.
Or green card holder, then it's fine.
Right, then it's fine. But if this isn't a case where like you have it happens a lot where you have people out of the country that want to live close to New York and they want to buy a place because they come for business and they're a foreigner completely. That's when you would let them know that. Failure of buyer sellers to close. So this is a thing that comes up a lot. I don't want to spend too much time, but like my understanding is you can't really force somebody to close, right?
It's super hard to. So what, like I said before, everything's legal until someone tells you it's not, right? So if the buyer, let's say I'm buying from George here, and I say, hey, I don't want to buy anymore. I'm not going to perform. Well, the deposit isn't automatically forfeited. You can't just take it, but it just stays in the the attorney's trust account until we come to some sort of negotiation. He can, let's say I'm supposed to buy for 400,000. I say no. He turns around and sells it to Joe over there for 350. That $50,000 difference are damages. So if he were to sue and he were to prove, hey, I have $50,000 worth of damages, if he goes to a judge and the judge rules in his favor, he can take that 50 from the deposit, but whatever else is left over would be returned to me at that point, minus any legal fees and so on and so forth. It is rather hard. I wouldn't say hard, but it is sometimes prohibitively expensive to do that. But I also have 50,000 in escrow. I probably want that money. So there's some sort of negotiation that happens. Conversely, if we're under contract and I'm to buy his house and he decides, well, I was going to get a new job in Florida, but that job fell through. I don't want to sell it anymore. I'm going to stay here. Can I sue him to compel the judge to force him to sell the house to me? It's real hard to. I would say most of the time you're not going to be able to. But I can say, look, I did X, Y, and Z in trying to buy this house. I ended up buying this other house. I have this much in damages. I want to sue him for money. More doable, sometimes prohibitively expensive. Usually it's if it's some very egregious conduct, then you have a bigger chance of being able to sue and to win. But it's around like 10, 15,000 to start an action. So if it's your costs are anything less than that, it's probably not worth it.
So
for attorney fees. I mean, here's the thing, right? If you have a good relationship with the other side, you can say, look, I understand your circumstances. You wanted to move, you wanted to leave and change circumstances for you. Can you reimburse me for some of my expenses? If you got a good relationship, you've got good goodwill between the two of you, he might say, look, I understand that too. And look, I'll pay you back whatever it is, because I understand, right? If one side just doesn't care, like, yeah, screw you, like, I'm just gonna do whatever I want to do, then, you might feel really bad, and legally you have the options to pursue them, but it might not make financial sense to do so. You still have the option.
Right. And most attorneys that represent you on the transaction don't do litigation.
I'm not a litigation
Right.
attorney.
So that's something that you guys,
I'm sorry, Joe.
So that's one thing that people don't understand. Like I've had buyers that say like, oh, I'm just walking away and like, like I'm going to sue them to try to, I'm like, look, you're not, I'm being a little exaggerated, but you're not going to force somebody to sell the property. Let's understand that in practicality, it's not going to happen. Best thing you could do is quantify how much you want to be accept to cancel the contract. That's the best solution a lot of times. It's like, look, you spent X amount, and then for your troubles, let's say you spent $1,800, and then for your troubles, ask them for $5,000. If they agree to give you $5,000, and then you mutually agree to part ways, that's really the best outcome a lot of times. Yeah. And it can work the other way around. It's very hard. And then most people assume that the deposit, like if somebody breaches, they keep the deposit. That's not how it works, right? It depends on like damages and stuff like that too. So like I have situations where I've gone to sell, somebody's walked away from the deal by no contingency. So technically you think they're going to lose their money, but you really have to sue and go through the whole process. What we do is we hold that in escrow and then we try to resell it. If we resell it for more and there's no damages, just let that go. Like there's no loss.
That's also why, if you go back to the first page of the contract, the deposit amounts, the initial and the additional deposit, and the balance at closing, as a seller side, you typically want to maximize the additional and initial deposits, because then the buyer has more skin in the game. They have more incentive to perform. Whereas on the buyer side, you typically want to minimize that as much as possible, but still keep the seller interested in order to sell the property to you.
Yeah, so that's, again, we could really go on and on about it, but just I think that not a lot of agents understand that.
Oh, no, that happened to us in one of our transactions where the seller sold off. And then the buyer ended up like canceling.
Yeah.
The attorney suggested, she said that you can try to like.
You can try to sue.
But she kind of like, I was steering him not to, because she said, I don't know how long it's gonna take or.
And the cost, yeah.
The
So,
cost, yeah.
He ended up like not doing it. But
Yeah, no, and I think agents should be aware of that, because God forbid you have that situation. You're the one that's going to be kind of dealing with the venting, right? We're kind of the therapist. So I just tell my people right from the beginning, like, look, the deposit, like it's tough, and you can't really sue for performance. I mean, you can, but it's not practical.
I mean,
hard.
some agents
Real
also,
hard.
like tell their buyers, well, you can lose your deposit, but technically that's not true, right? Like,
They could, I mean, theoretically they could. Will they? But, you know, I had somebody try to get it, loud with me the other day. And he's like, oh, we have all these costs that are down. We're going to sue you for. I'm like, you know how much litigation costs, bro? Like, shut up. You don't have enough money. Like, and I just calmed them down real quick. So that happens, like you can use that.
You're saying at minimum, let's say 10,000. If you're not losing that much,
Even more,
just leave
bro.
it alone.
Even more.
It depends.
I mean, you could pay an attorney, just write a letter, right? An attorney letter that says, hey, you can get an attorney to write a real scary letter that says, hey, if you don't do X, Y, and Z, I'm going to sue you, blah, 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 blah. And sometimes it's enough to push the ball forward, because it's prohibitively expensive, but at the same time, you're dealing with people and dealing with emotions. And some people might say, I'm going to spend $100,000 in order to make 5 because I just want to screw with this guy.
yeah.
You don't want to deal with that guy either.
So it really depends.
I've known those guys. It
Yeah.
happens. In reality, I would say, honestly, unless you're facing a loss of like 25, because you might spend 15 trying to get those 25. So you end up with 10.
Yeah, because the attorney is not going to do it on contingency. So sometimes if you get personal injury, if you see those ads, hey, if you only pay the lawyer if you win your lawsuit, that's because that person got injured. You're talking about $100 million of potential awards. Yeah. Whereas for this, usually you're paying the lawyer ahead of time, because they're like, well, I don't know if you're going to win this. If you want to put time and effort into this, I need to be paid up front. So that's why.
And there's no guarantee
There's
either.
no guarantee.
So you pay that fee, no guarantee of success, you could lose that fee. So definitely something I wanted to talk about. Consumer information statement acknowledgement. We have to have a CIS, guys. Like consumer information statement just says what kind of agent you're acting as. I'll just do this one quickly. Declaration of business relationship just says I am this person licensed with this brokerage and I am representing this person, right? Just check the box, put the names. Please, please, please always fill this out. I've seen agents leave it blank. The section that talks about the REC license ID, like that's your license number. That's not your MLS number. I've seen a lot of offers come across where the other agent puts my MLS number. This is to protect the buyer and the seller, to show you who the licensee is that's dealing with this. Do this correctly. It's a super simple search. You can pop into the MLS and click next to the MLS. There's like a little quotation that says LIC, it's license. You can click on that and it shows you your state license for whomever. I can find you can Google NJ real estate licensee search, put in the last name and all the people pop up. So fill this out correctly. Most attorneys would want this filled out correctly. I, as a broker, will tell you fill it out correctly. And then just fill in all the fields. One thing I'll say here, where it says commission for the listing firm, right above it, it says per listing agreement. Why? Because we, as listing agents, don't have to disclose how much commission we're being paid to the buyer side. So you just leave that blank as per listing agent. You don't touch that. I will say you should put in the bottom where it says commission due participating firm. If you leave that blank, you're leaving yourself open, because what happens is the MLS advertises how much they're offering out. but you could theoretically negotiate a smaller commission for your client to get their offer accepted, or something. You could negotiate a flat fee, whatever it is. Put in your commission. So if on the MLS it says 2.5% minus 200, write that in, 2.5% minus 200. If you leave it blank and then the other agent fills it in with something, I mean, look, it's very unethical and like you'll probably catch it, but I've seen situations where it's the reverse. The buyer's agent tries to put in a higher commission. I don't know if on purpose or they misread it, but if I didn't catch that, technically I'd be paying that out and losing it out from my side because the seller agreed to pay a full amount and then whatever we're offering off, I'm taking the other part. I've actually seen situations where title companies don't check the contract. So if you give a commission bill to the title company, they'll put that on there. Unless the seller catches it, that amount gets paid. I've seen it happen. So you guys do your due diligence. Make sure that whatever you're putting on there is what's advertised in the MLS, and then that's what you put in for your commission statement. Equitable lien just talks about our commission being a lien on the property. However, every single attorney removes that right away. I'm like, these mothers. Why do you guys get rid of it?
Well, it doesn't help the buyer. For me, as the buyer's attorney, it doesn't help the buyer. It
Right.
essentially says if you don't get your commission, you can put a lien on the property. But the buyer's not the one paying the lien, and it's not really his responsibility to make sure the seller pays it to you.
Right.
But that's what the title company is there to disperse it. So if you get your statements in on time, title company should be able to issue your checks in a timely fashion. So usually just remove that all the time.
Yeah, there's some broker protections here, but both attorneys don't care about us and they'll remove it right away. Once. So guys, yeah, sorry about that. 32, disclosure, the buyer or the seller is a real estate licensee. It's important. If your client is a real estate licensee, by law, you have to disclose that. You disclose it on your listing by saying that one of the members of the LLC has a real estate license, whatever. And on the contract, you have to put the actual person's name and what license they hold. Brokers to receive closing disclosure and other documents. New Jersey real estate licensee. Yeah. Yep. This provides that we're going to get copies of all the documents involved with the transaction. We have to, as brokers, hold on to that documentation. And this just gives us the legal right to receive them. It's not like they can withhold it from us. Professional referrals, it just says like, look, we can give you referrals, but you're not forced to do business with any of them. But I'm also, if I refer somebody, you can't sue me for their incompetence kind of thing. Anything else on that?
No,
Pretty much that.
accurate. Yeah.
Attorney review clause, I'll let you just do that.
Well, this is the provision that allows us to make changes to the contract to essentially say, hey, we're going to disprove this contract within this 3-day period. So what I usually tell clients is it's 3 days to start attorney review, but attorney review can last as long as it takes until both sides come to an agreement. So the longest attorney review period I had was like 2 months. And that was at the beginning of COVID when the buyers said, I don't know if I really want to buy this property because of COVID. And the seller said, I actually don't know if I want to sell this property because I have to stay here. And so they just kept it open for 2 months. And they said, well, okay, we kind of on a handshake deal. And at some point they ended up terminating that because the buyer ended up not being able to qualify for a loan because of COVID at that time. So
I had one take a month just because the attorney on the seller side was stupid slow.
yeah, that sometimes happens too,
Yeah.
where they're just not responsive.
And yeah, I mean, technically they don't have to finish attorney review in 3 days. Some people think that that's what it is. It's not.
No, it's already, yeah.
So if you send your first letter, it's not like an automatic waiver at the 3rd day. Okay, we're on the contract. That's not how it works. So it's important that you guys know that. Notice of disapproval. That's what Kyle was saying about how you have to send a notice saying, hey, we see the contract, we disapprove of it. Some people get shocked, they're like scared when they say, oh, what do you mean you disapprove of the contract? That's legal language. They have to legally disapprove of the contract in order to make these changes and keep it open for the review, right?
What I normally do on the seller side is I'll just send out an email that says this contract is disapproved for attorney review purposes, comma, I'll send out my response pending buyer's letter, because usually the buyer side sends it out first and the seller side will go and respond. Some agents will say, oh, well, you've terminated my contract. I have nothing to go forward with. Like, they can go to accept any other offer. Practically speaking, they can go accept any other offer anyway, because during attorney review, they can terminate our contract and just go with somebody else. This is really just the formality in order to begin the attorney review process. If neither side sends out a letter during that 3-day period, theoretically, you are now under a binding contract and the attorney review period is over. But if both sides don't care and they say, hey, we'll just extend it, oops, then it's fine.
But that's why they do that.
That's what I'm saying this way. Yeah.
Notices just says like anything that regards this is going to be by certified mail, fax, email, recognized overnight courier, things like that. You know, back in the day, it had to be by certified mail, and then they started, as technology came out, they started adding these different ways to give notices, and now email is acceptable.
Yeah.
Some attorneys still do that.
Some attorneys still
Yeah.
do fax. Oh gosh.
That's so frustrating.
The worst.
I know of one, Linden, right?
Well, when you-
Oh, okay, so I know of two now. No assignment. This is this is something that when you guys are dealing with like investors and like buying properties off market, the assignment of the contract essentially means like whoever's being put here as the buyer is the buyer. They're not assigning that contract to somebody else, because sometimes what happens is like you can enter into a contract with a seller and then you can sell your right to somebody else. The standard real estate contract that we have does not allow for assignments. So whoever the buyer is the buyer. So if your client's looking to flip a contract, they cannot use this, or if they do it, they have to make sure that that gets removed in attorney review. Electronic signatures, this was a disclosure that was added in. Obviously, as the laws change and our technology advances, we are able to get electronic signatures for the contract and that be acceptable. Because at the end of the day, they have to do wet signatures for the closings for the most part. So this allows us to at least start remotely. Anything on these?
No, good.
Corporate resolutions, this is kind of what we're talking about. If it is a corporate entity like an LLC, you want to ask for any documents, a certificate of formation and any operating agreements. So if you're representing a buyer as an LLC, ask for those certificates and provide them to the attorney. If not, they're going to ask for it anyway, but that will help.
If you're doing an estate sale, if you're buying from, if somebody passes away and their executor is the one who's selling the property, it's really helpful for me as an attorney if you get what's called the letters testamentary or the letters of administration. These are the letters from the court that certify that whoever is signing on behalf of the estate has legal authority to do so. I'm going to ask for it anyway, but if you have it ahead of time, it makes my job much easier.
And this is the part where you can see if your client is authorized to sign on behalf of that LLC. So sometimes I deal with people that may be like, you know, people that do the running around for the owners, but if they're not an authorized signer, I don't have a valid contract.
Yeah.
Okay, so that's important. Entire agreement, parties liable.
It says that everything that we've agreed to, we've talked about, is written here. So if I sign a contract and I say, oh, really, you know, I'm buying it for 450, but it says 400 here, it's gonna be 400 because it's what's written. It's not what we've talked about.
Yeah. So like whatever terms, if the seller says, oh, well, you at the walkthrough told me this, like, look, this is right here. It says you signed. This is the entire agreement. We might have discussed that something changed in between. That's not right. It's not ethical. It's not, you know, good business, but theoretically it's legal that only the things that are here in this contract are going to be enforceable. And then applicable laws just says that, you know, this government can, New Jersey laws and US government laws can oversee and supersede any single clause in here, right?
Yeah, you're in Jersey, you're being governed by Jersey law. That's what it is.
And addenda. So this is the section where you check off different things. A lot of agents don't do this. I'm not going to go into every single one of them, but real quick, the big ones are buyer's property sales contingency. If your buyer is buying subject to the sale, you should check that box, get the addenda, fill it out, and submit it. It'll state what the address of the house is, by when they have to be under contract in order to, you know, part of this contingency. It's much longer language. Look for that addenda, fill it out. If you're buying a condo, condo that has a homeowners association, that addenda requires the address of the condo association, the phone number, the monthly fees, the application fees, lots of important information. Make sure you get that. Yeah, everything's in transaction desk. If every realtor also has zip forms by default from the state, you can get it all on zip forms. Transaction desk and zip forms are the same company, so it's all imported from there. We have all of those addenda right there. If you're doing an FHA or VA loan, a lot of times agents don't include the FHA mandatory clause. So then during the contract, the lenders are trying to chase it down. If you want a quick closing, get the FHA addendum. You have it already. Just get that signed and submitted, and you'll save time. Coronavirus. When are we gonna stop doing this?
Yeah, I don't know.
Like,
We'll come out with monkeypox next.
yeah, seriously, the monkeypox addendum is coming soon. Lead-based paint disclosure, any house built before 1978, you have to include the LBP. A lot of people leave that off. There are requirements. These are documents that you have to include with your contract. New construction protects people, like you talked about the abatements and, you know, when the house is going to be delivered, things like that. Private suit. I mean, look, it's all there. The big ones are that I've seen a lot is FHA addendum, property sale addendum, HOAs, Seller's concession, the seller's concession has more details about what that money looks like and how much. A lot of people just write it in at 43. It's good to write it in because at least it's like stated in multiple places, but the addenda has all the language in it already. So that you really should do that. Solar panels, that's a big one. I mean, we could do a whole training on that, like whether they're leased or owned, are they going to be removed? Can the lease be transferred? Is it a contingency? There's a lot of problems that can happen, so.
Always let us know. As an attorney, I never know if there's a solar panel unless somebody tells me, or unless it's listed on the MLS, or it comes up in the inspection.
Yeah, guys, look,
Tell me if there's a solar panel.
a solar panel lease that comes with the property and the buyer's accepting it, that can affect their mortgage.
Yeah, because that changes it, that's an income ratio, right? Yeah, transfer fee, they might not qualify for it. There's a whole bunch of things.
So like, just make sure that anything, like if there's an underground fuel tank, there's an addendum to it. Anything that might apply to your transaction, check the box and get the addendum. It's all to protect yourself as an agent, but also your client, because all that language is formulated as consumer protection,
For the pool, that includes above ground or on.
Both, and there's like a box you can check if it's in ground, above ground, age of liner, like all these different things. Sellers disclosures, they're not part of the contract here, but I will tell you, like, we are not required to have our seller sign disclosures. As an agent, when I represent my seller, I don't ask them to do a seller's disclosure, because again, less information that they're representing, the better. A lot of agents just by default make the clients do it, and a lot of buyers agents ask me like, oh, where's your seller's disclosure? I don't have one. Just as simple as that. You don't have to, like, no, we don't even need a waiver. It's not required. So yeah, again, that's anything you want to add? Yeah, but I'll tell you that for the most part,
Most people do. I agree. When I'm representing a seller, I say, hey, everything's for informational purposes only, not to be relied upon, do your own due diligence, blah, blah, blah. But it's also helpful for you're in a seller's market right now. So you have a ton of buyers who are looking. If it were flipped, you might have fewer buyers and the sellers might want to disclose, hey, I just replaced the AC unit, 2 years ago. This is all new, and it makes your property probably a little bit more, but you probably know better, make it more appealing. But in this market, it makes sense if you don't want to fill it out. Because you already have a lot of buyers, not there.
Yeah, my stance is always, if I'm representing the seller, I want to have them give as little information as possible, just so that nothing can come back and bite them. Yeah. It's just and then if they did do any updates and stuff, I usually just put that on the MLS remarks. By default, my stance is no sellers disclosure. Now, of course, if I represent the buyer, I want the seller's disclosure, and most agents don't know and they think it's required. So, that's on them.
I just want to point out, we didn't talk that much about the underground fuel tank. Just know that during inspection, you want to do an underground oil tank sweep. Yeah, a tank sweep. It's not like in the city here, much less common. You probably won't need one, it's a lot of interference. But in the past, they were allowed to leave oil tanks in the ground, cut the top off, drain the oil filled with sand. It's not really allowed anymore. So you do want to know if it's there. If you find one, it's usually the seller's responsibility to take it out. You can't force them to take it out. But as a buyer, you might also say, well, you don't take it out on one. It's a conversation point. You can't really force people to buy it one way or the other.
And it is a big one. I will say if the house, like back in like the 60s, like gas became very much available in these areas. But if the houses around here were built in the 1910s, 20s, 30s, a lot of these houses at some point had oil tanks. Yep. And sometimes they just cut the thing and there might not be any visual presence of it. And that's why you do those tank sweeps. Very, very important for sure.
I once heard of a house. It wasn't the house that I was buying, but I heard of a house that had 3 oil tanks in the property.
Oh yeah, I've had that.
Yeah. So it's like you pull out one, you're not expecting another. You pull out another. There's another one.
Yeah, I've had seller like listing agents tell me, oh, but the oil tank was in the basement, so you don't need to do a sweep. Screw that. Like they could have had an oil tank in the ground that they decommissioned, left there, then put one in the basement because it was more convenient. Then they removed it from the basement, and then they say, oh, we're good. No, unless you give me a oil tank sweep saying that there's nothing, I'm telling my clients, spend that $200 to $250. It's well worth it. Peace of mind for yourself.
You sleep better.
And then the other thing is with the underground fuel tanks, it might not just have to be fuel tanks. Sometimes there are other metal objects. So when you do the tank sweep, then you discover an area of interest. You can negotiate the seller paying for the excavation to see what it is, because if it's a big enough metal thing, there might be things. There was a house I sold here in Broadway where there was a metal disturbance. It wasn't big enough to be an oil tank, but we negotiated that the seller would pay the excavation and then we'll deal with it. It turns out that I guess at some point it was like a barrel, a drum that they filled with chemicals, and they freaking buried it. They buried it and covered it. Yeah, so like that was a big thing. Yeah, it wasn't an oil tank, but we did a tank sweep. It came up. Yeah, there's all, like, I had one time where it was a buried fridge in the backyard too. I've seen all types of shit. They filled out an in-ground, but yeah, no, I've seen it. So like, tank sweeps, like they find different things too. So that's important. Yeah, here in additional provisions, you can write in pretty much anything you want. Remember that this is being incorporated into a contract. So like I've had agents that will put in things that I'm like why would you write that? Like it's like such stupid stuff. I will say that I've seen some creative things in here. Like for example, I saw one where it was like, and you could tell like, okay, if you accept this offer, the provision says that the house will be removed off the market, right? So when you sign the offer, the listing agent has to remove it, right? Because here's the thing, like as a listing agent, if I accept an offer, I'm supposed to mark it as A-RIP, but it doesn't mean that I can't show it anymore. So I can continue showings, I can do an open house, I can do whatever. But if you put in a provision here that says no more showings after this is signed, that person is now acting against the wishes of the buyer and seller that they agreed to if they do those showings. So that's an important thing too. You could put in anything here, and then the attorneys will most likely to not clean up the language a little bit because
Let me know what the intent is.
sometimes they just put like chicken scratch and they're like, what? You know, so that's pretty much that.
Type it if you can. I've had people just handwrite it and it just looks like it's all over the place again.
On that note, I will just say one last thing. If you make any changes, let's say you submit the offer, the buyer sign, you write everything up, the buyer signs it, you send it over. If the seller marks up any section of this contract and sends it back signed, you're supposed to get the buyer and the seller to initial next to the changes. Okay, because that could happen where the seller makes a change, signs it, sends it to the attorney. He's like, wait, you just made a substantial change to the contract. We need to both kind of sign off on it. I think that's really the last thing. Anything else you want to add to the contract?
No, this is it. I mean, it's sure there's plenty of.
Yeah, there's plenty of things, but we've been here for an hour and a half.
Yeah.
Yeah. So I just kind of want to end it on that. I'm going to end the sharing screen. I really thank you, Kyle, for attending this and helping us out and telling us some information. If you guys want, I'm going to include Kyle's information on here. And if you have any questions, obviously he works residential real estate and here in our market, he's like maybe 15 minutes here from our office. So anything you guys might need, definitely hit up Kyle. Thank you guys for tuning in. I'm going to save this and upload it. So I'll talk to you guys later. Thanks. Let's stop the share and let's end the recording.